The case of SEC versus Ripple XRP. There is a serious debate about whether cryptocurrencies truly are money. On one hand, cryptocurrencies are primarily used to buy and sell things, which make them fit the definition of cash better than that of securities. But their prices fluctuate too often to serve as useful units of accounts. This debate is the foundation of the case between the US SEC and Ripple XRP. If the United States SEC can get XRP regulated as a security, it would gain regulatory authority over other cryptocurrencies too. This is the reason the lawsuit has such huge connotations on the entire cryptocurrency market, and will set a precedent for the cryptocurrency industry. Based on existing US securities laws, currencies are not securities. Cash equivalents like treasuries and GICs are securities, but physical cash is not. In December 2020, the SEC brought a suit against Ripple Labs, alleging that the company's CEO, Brad Garlinghouse, and co-founder Chris Larsen had engaged in illegal security offerings, during which they each sold XRP for hundreds of millions of dollars. Definition of securities. So, what are securities? The U.S. Securities Act defines the term security by a catalog of examples. The definition doesn't have any qualitative criteria. For instance, shares are commonly defined as securities by publicly listed firms to acquire funding. It can be any of the terms: stocks, bonds, options, warrant, or a dozen others, as long as they are publicly listed by a public limited company as a means of acquiring fund. History of XRP. With the definition of securities out of the way, let's go back to the history of XRP and how all this controversy started. The Ripple payment network was launched in 2004, with Ryan Fugger, the founder, at the helm. In 2012, Jed McCaleb and Chris Larsen took over and created the XRP Ledger, Ripple's decentralized public blockchain. McCaleb would serve as Chief Technology Officer until 2013. Today, the company is headed by Brad Garlinghouse, CEO, Christina Campbell, CFO, and David Schwartz, CTO. This was Ripple Labs' entry into the fintech sphere with the promise to provide financial institutions with speedy and low-cost clearance of cross-border money transfers with the help of blockchain technology. To ensure this, the business created the RippleNet network, on which trades in the form of a cryptocurrency called XRP were cleared and settled in real time. It was smart. It was revolutionary. This was more efficient than using the traditional international wire transfer settlement systems in place. Individuals used XRP as a substitute for traditional banking, making the transfer of currencies and money management even more accessible across borders. Financial institutions used the network to bridge currencies for quicker transaction procedures between countries. Meanwhile, developers are encouraged to create fast, eco-friendly applications on the open-source platform. XRP can be conveyed across blockchains, making it a negotiable form of currency. This was a feature that was very desirable, especially at the budding years of cryptocurrencies. Over several years, XRP grew beyond the bounds of its stated application. The company's founders raised funds by using XRP to facilitate cross-border payments as digital assets in 2013. XRP gets sued. This would not go down well with the United States Securities and Exchange Commission, SEC, so they filed a suit against Ripple Labs and its current and previous CEOs as a result in 2020. The agency sued the crypto company for alleged securities laws violations. The SEC has argued that the company failed to register XRP, which was then worth roughly $1.4 billion as securities. The SEC alleged that the executives held an initial public offering, IPO, of XRP, which was an unregistered security at the time of raising capital. According to the complaint, Ripple raised funds by selling XRP tokens in unregistered security offerings to traders in the United States and around the world. Also, the company offered billions of XRP in exchange for non-fiat services like labor and market making. The big and central question here, that will be answered by the court in a matter of time, is whether XRP should be considered a security. And this is the million-dollar question that had the entire cryptocurrency market biting its nails. The case has dragged on for more than a year and a half and centers on the SEC's argument that some cryptocurrencies should be regulated as securities. Ripple rejected that claim. Ripple Labs chair, Chris Larsen, and Garlinghouse claim the sales were all legal. Their retort were based on the Howey test from a U.S. court case, which determines if an asset is a security. The Howey test refers to the U.S. Supreme Court case for ascertaining whether a transaction suffices as an investment contract. If a deal is found to be an investment contract, it is seen as a security. While Ripple does not deny the trade of XRP, the cryptocurrency company argues that it does not meet the criteria of the Howey test. Specifically, it failed to meet the first rule, which requires an investment contract. The company claims that Ripple does not have a written implicit contract, hence the sales were legal. The SEC has argued that it does indeed meet the investment of money criteria of the Howey test. On the 17th of September 2022, Ripple Labs and the SEC filed motions for summary judgment to the judge in the case, Annalise Torres, of the U.S. District Court for the Southern District of New York. The court reviewed and granted the request for the Chamber of Digital Commerce 2 days after the filings. An American blockchain advocacy group filed an amicus curiae brief which supported the company's argument. It said, the court has asserted previously, correctly, that a digital asset is not a security simply by being represented in digital form or recorded on a blockchain ledger. According to the defense attorney James Filon, the SEC has taken no position on the brief. Nevertheless, the SEC said it may request more time if any more amicus briefs are granted. In reply, Ripple's defense team pointed out how the SEC was only trying to waste more time. This is yet another transparent attempt to further delay the resolution of this case, and the court should reject it. Another motion was granted on September 21st that afforded deadlines for motions to the seal request that prevent evidence in a case from being made public. Garlinghouse later appeared on Fox Business on September 2022, where he suggested it was improbable the case would go to trial, and that he anticipated a ruling from the judge. Garlinghouse criticized the agency again the following day on CNBC. We think this is just a gross overreach of the SEC, trying to seize control of that doubt that has existed, Garlinghouse said. The Hinman documents. Recently, Judge Torres dictated that the SEC hand over the documents by the former SEC Corporation Finance Division Director, William Hinman. The Hinman documents could very well be a fundamental piece of evidence for Ripple, as they reaffirm their position that XRP is not a security. The judge overruled the SEC's objection on September 29, 2022, after the commission asserted it was secured by deliberative process privilege. Ripple slams SEC over amicus brief opposition. More recently, Tapjets, the private charter jet company and payment provider iRemit, have requested to submit amicus briefs in aid of Ripple. The company argued that the blockchain company is essential to their business. The SEC asked the judge to deny these requests, arguing that the letters failed to state the connection with the ongoing case. In reply, Ripple stressed strongly that the briefs offer an important view to the court on whether investors anticipated XRP profits. If the SEC cannot process the truthfulness of such claims, then it had no business bringing these proceedings in the first place. Judge Torres sanctioned Tapjets and iRemit's request to submit these briefs on October 11. The companies were given 3 days to file the documents. The court's ruling in this case could very well have a ripple effect on the cryptocurrency world, pun intended. Some have said that Ripple is fighting this lawsuit on behalf of the entire cryptocurrency industry. After all, not only is Ripple standing by their argument that XRP is not a security, but they have also spent more than $100 million in doing so. That is, according to their company. Current status. It does seem like the court is slowly coming to a verdict, as during a mainnet fireside chat recently, Garlinghouse said it would take as little as 2 months or as much as 6 to conclude what began in December 2020. A settlement reached with the SEC would be possible if only the regulator states that all XRP sales and secondary sales by Ripple were not securities. Another big question investors are being made to ask is whether holding on to Ripple is worth the risk. Garlinghouse has said that there are plans for the company to explore the possibility of an initial public offering, IPO, as soon as the lawsuit is concluded. The verdict in the lawsuit would turn things around for XRP and would mean a big victory for all cryptocurrencies to be handled as non-securities, therefore not subject to regulation by the SEC. We are sure you enjoyed the video, and like Oliver Twist, you want more, so click that subscribe button right now and also smash the like button to show us you love the video. See you again.